And welcome to this episode of the Good Citizen Podcast. Today, I want to jump into the topic of preparing for a post-Dobbs America. Now, some of you may be thinking, why is this titled Preparing for a Post-Roe America? It is because if law practice has taught me anything, it is that you wait for a final signed opinion before declaring the outcome of a case. Now, there certainly is some great evidence pointing towards the leaked draft opinion being the actual decision of the court, though certainly some of the language would be changed due to concurrences and dissents, and Justice Alito having a chance to respond to those. However, it is not final until it is final. And so prudence would say, hey, let's prepare for every potential outcome so we might not be surprised if something different comes from the Supreme Court. So today I want to jump into a little bit of the kind of recent cultural developments, even since the leaked draft opinion. Talk some about, well, what are the outcomes? We'll go through that pretty briefly. Again, I think there's some good indicators that the decision to send the issue back to the states, overturn Roe versus Wade and Planned Parenthood versus Casey, I think there's some strong evidence there. But what are the potential outcomes? Next, if the Dobbs draft, the leaked draft, is the actual decision of the court, what are some of the implications there? I'll dive into a few of the legal issues that might happen pretty quickly after Dobbs, looking back at some of the states. And then finally, just how would the church respond? Some talking points, but then also what are some of the practical steps that churches can take to support both the child and the mother and to create a society where both can flourish. So let's jump in. What are some of the things that have happened since the initial leaked draft? And if you've been following the news, some of these are probably familiar to you, but I did want to point out a few of them, and some of them lesser well known than others. And first of all, is that there have been some additional leaks as reported by the Washington Post, and I'll just read part of this article. It says the leaked draft opinion is dated in February and is almost surely obsolete now, as justices have had time to offer dissents and revisions. But as of last week, the majority of 5 justices to strike Roe remains intact, according to 3 conservatives close to the court who, like other people, or like others, spoke on the conditions of anonymity. And so again, there have been, it says 3 conservatives close to the court have reported that majority remains intact, and that would be a recent conversation. And then a person close to the most conservative members of the court said Roberts told his fellow jurist in a private conference in early December that he planned to uphold the state law and write an opinion that left Roe and Casey in place for now. But the other conservatives were more interested in an opinion that overturned the precedents. So if you hadn't heard of kind of the other leaks coming from specifically conservatives, is how they're described in the article, saying that majority to strike down Roe and Casey remains. So certainly encouraging. It also perhaps kind of settles, well, who would have had the motivation to leak this? Someone thought maybe it was a conservative clerk or someone on the conservative side, because one of the justices in the majority had flipped or changed their opinion. It does seem now that if this is a rock solid decision that Roe and Casey will be overturned, it would seem like the motivation would be to go ahead and leak this from someone on the more progressive side. Again, who knows? And who knows exactly who leaked it? We may never know. But it does seem like someone wanted to get that out there so people could see what was going on and respond to it. Also, some other issues. We see, I think, somewhat the straining, the stretching of the fabric of our democracy. Now, I also often mention that our republic has often been a bit rowdy. All right, you look back at American history, and that is certainly true. You think of the election of Andrew Jackson, and he comes to the White House, and many of the people from the West come in, and there are people tracking mud to the White House, throwing a big party. You certainly think about dueling. So again, the history of the American Republic has been rowdy, but we're certainly beginning to see just the collision of worldviews and people being so strongly animated and angry about what might come from the Supreme Court. So things like protesters outside of Justice Kavanaugh's home. And one that, if you didn't catch this, it's an important one, is that a pro-life group called Wisconsin Family Action had their office burned. There were actually Molotov cocktails thrown into the office. Windows were broken. And then there was a message scrawled outside stating, if abortion isn't safe, you aren't either. And an anarchist group has actually taken responsibility. Now, I work with Indiana Family Institute, which would be a sister organization of Wisconsin Family Action. I know the individuals that work there. And so this one hit pretty close to home. And if you want to just kind of see the tone of the discourse around this topic, if you want to listen to that, I will link in the show notes. I thought about playing it, but decided not to. But some of the voicemails that have been left at the Wisconsin Family Action since individuals learned about the attack, and these are not, hey, we're praying for you. These are quite different, calling them all sorts of names, and wishing destruction on them, all sorts of things. So I'll let you actually listen to those particular voicemails on your own. I will warn you that they are explicit. It's why I decided not to play them here. But I think it is helpful just to hear what those that are promoting the sanctity of life are receiving. Some of these messages and threats. Also, we've seen protesters outside a Catholic church disrupted a pro-life event, graffitied another church, and then at least 2 pregnancy care centers have been graffitied as well. And so certainly we're seeing the pro-choice side, those that oppose the sanctity of life, protection of the unborn, them coming out in force and definitely being upset about this. And I would note, I had a pastor ask me, what can you help me understand why the opposition to this, the opposition to the sanctity of life is so vehement, that it's just so angry. And I, as a pastor, and if you're listening to this and you're not a Christian, understand I am speaking from a biblical Christian perspective, and I do consider this to be a form of spiritual warfare, that this is a spiritual issue that is being wrestled with at a national level. And so it has such an import. And I think that may in some ways explain it. So now let's move into kind of potential outcomes. Now, again, I am certainly encouraged by the draft. I certainly am praying that the basic decision that we see in the leaked draft opinion becomes the law of the land. But again, just prudence says, hey, well, what are some of those outcomes? We should be prepared for those as well, rather than just kind of being angry. And I certainly would be sorely disappointed and upset if that happens. But again, this was just a draft opinion. We don't know what the final order of the court's going to be. So potential outcomes are certainly that Roe and Casey could be overturned. If you've read the draft opinion, you know very clearly what that would look like, and the issue of abortion would return to the states. Another kind of middle ground, and actually there were a number of attorneys in the pro-life area, in the pro-life movement, that thought that perhaps this middle ground option would probably be the decision of the court. And we're concerned that that's how the case would turn out. And basically what would happen in that case, as I read at the very beginning, you heard Justice Roberts describe this position where he'd uphold the Mississippi law, which banned abortions after 15 weeks, but would leave Roe and Casey in place. So this middle ground would be something along the lines of doing away with the viability standard. And if you aren't familiar with that, basically the viability standard said, well, as long as a kid can survive outside of the womb, well, you can't allow an abortion once they're viable, which never made much sense to me, because so the baby that is weaker and unable to defend themselves, in a sense, we can kill them, but you will protect the life of those once they reach the viability area. In the Mississippi law at 15 weeks, very clearly, at 15 weeks, a baby's not viable. And also, these decisions would probably clarify what we have termed the undue burden test, what Supreme Court has termed the undue burden test, which has always been very ambiguous, very hard to understand exactly what it means in particular contexts. So again, option number 1, overturn, return to the states. 2, do away with the viability standard, clarify the undue burden test. And the Mississippi law would probably stand, a 15-week ban, but something like a heartbeat bill probably would not withstand scrutiny under that constitutional standard. And again, Justice Roberts, again, from the leak, if that's to be believed, it seems like he would be pursuing that, but there would be enough votes to overturn. And then the final possibility would be that the Supreme Court would find the law unconstitutional, but try to clarify Roe and Casey in some sense. That seems fairly unlikely because the court declined to even hear the Texas case. If you remember, the law from Texas that kind of deputized the people in Texas to go ahead and enforce some of their abortion laws there. And so those are the three potential outcomes: overturn, return to the states, do away with viability, clarify the undue burden test, or just find the law, the Mississippi law, unconstitutional and clarify Roe and Casey. So again, just potential outcomes. I will link in the show notes to a blog post that we wrote that clarifies and kind of goes through all of that if you're interested in reviewing it. So those are kind of potential outcomes. Next, we move to the idea of, well, if this Dobbs draft, the draft opinion that has been leaked, is going to be the actual law of the land, what are some of the key parts of that? What does it mean? And then what's going to happen if the issue gets thrown back to the states? What are some of the legal implications? Because there's going to be a flurry of legal activity for sure. So many of you have probably listened to podcasts or read articles at this point, so I won't spend a lot of time. But I did want to note just a few issues just to summarize, and has been one of our key distinctives here. We're not always trying to be kind of the first organization out with a news story. Rather, we kind of look at it and then what do we do with it? So kind of what are some of the key things that you should know as you're explaining this and thinking through it yourself. And so one of the keys, of course, from the Dobbs draft is that abortion, the right to privacy, the right to abortion, was an unenumerated right. It's not clearly set out in the Constitution. And of course, Alito, as he's writing this, says that actually the right to privacy, the right to abortion specifically, is not found in the Constitution, and that Roe was kind of made up of whole cloth. And here's a piece of the opinion. Alito says, "We hold that Roe and Casey must be overruled. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision, including the one on which the defenders of Roe and Casey now chiefly rely, the Due Process Clause of the 14th Amendment. That provision has been held to guarantee some rights that are not mentioned in the Constitution, but any such right must be deeply rooted in the nation's history and tradition and implicit in the concept of ordered liberty. The right to abortion does not fall within this category." And so it clarifies, look, this is not in the Constitution. This is something that pro-life activists have been saying for 50 years, that if you read Roe, it reads more like a philosophical treatise on this topic. There was no precedent previously. Many of the states had already been regulating it and making laws on it. And so this was not a place for the Supreme Court to step into. The next big thing that Justice Alito tackles is, of course, the concept of stare decisis, and that if the court makes a decision, generally opinions after that decision have to fall in line. They have to fall in line with the precedent set by prior decisions of the court. So that, and this is important in a society, that we can expect, all right, here's what the law says. We can order our lives around the law, and we can build a society that way. But of course, stare decisis has never been an ultimate concept. Like, you make a decision once and you can't change it. In fact, Justice Alito takes great pains setting out all of these different cases where the Supreme Court has changed their opinion before. Things like Dred Scott, which found that African Americans were not quote unquote persons back towards in slavery days, finding that basically they were not persons. They didn't have rights under the U.S. Constitution. So, of course, that was wrongly decided and it was changed. Something like Plessy versus Ferguson, which in the context of segregation found that segregated schools didn't violate equal protection. And so those have been changed because they were wrongly decided. And so this idea that you can't change Roe or Casey because we've had it for 50 years doesn't stand up. You have to decide, is it wrongly decided? And Alito describes Roe as being egregiously wrong, not just wrong, but egregiously wrong. Another issue is that this particular draft opinion clarifies that this particular case is limited to the issue of abortion. Of course, you've probably seen articles from those opposed to the draft opinion saying, well, now isn't same-sex marriage up in the air? Aren't the right to contraception and those sorts of things, aren't they kind of up in the air because they're based on kind of a similar legal philosophy or a legal principle? And so here's what Alito specifically says about that. He says, the abortion right is also critically different from any other right that this court has held to fall within the 14th Amendment's protection of liberty. Roe's defenders characterize the abortion right as similar to the rights recognized in past decisions involving matters such as intimate sexual relations, contraception, and marriage. But abortion is fundamentally different, as both Roe and Casey acknowledge, because it destroys what those decisions called fetal life, what the law now before us describes as an unborn human being. So Justice Alito is making an attempt to clarify that this opinion, this particular decision, is about abortion, and it is different because it affects an unborn human life, a fetal life. So it's not just the life of the mother, not just the rights of the mother. There's another person involved here. And so that's something to clarify. Sometimes as I'm talking about this issue, listening to others about this issue, to understand that that's what this particular decision says. And the issue of same-sex marriage is a conversation for another day. This does at least raise the question of, what the definition of marriage and how we've looked at that particular issue. Is there an ability to maybe at some point in the future question that? Perhaps this particular decision raises it, but he does very closely limit this decision to the issue of abortion. Perhaps my favorite part, and I'll digress here for just a second, perhaps one of my favorite parts of the decision comes down to kind of a worldview issue, but we've been talking about on the podcast for a long time. And so if you've listened to the podcast for some time, I often differentiate between something I would refer to as ordered liberty. This idea that we are free to build a society according to God's good design, according to natural law, those sorts of things. And that's in opposition to what might be termed open license, that we're free to build a life according to our own design and kind of just shake our fist at the universe and say, I'm my own God, I get to make my own way. And that's a fundamental worldview crisis. And if there's anything that explains the crisis or the difference of opinion, the increasing polarization in our society, that's it. Well, there's this famous line in Planned Parenthood versus Casey, which I've often used as an example of this idea of kind of an open license. And in writing the opinion Justice Kennedy at the time, he says, at the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. I'll read that again. At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. And so Alito goes on to say, the court did not claim that this broadly framed right is absolute, and no such claim would be plausible. While individuals are certainly free to think and to say what they wish about existence, meaning, the universe, and the mystery of human life, they are not always free to act in accordance with those thoughts. License to act on the basis of such beliefs may correspond to one of the many understandings of liberty, but it is certainly not ordered liberty. And so again, just a point of privilege here. It's not directly operative on some of the legal issues here, but this statement by Justice Kennedy was one of kind of ultimate truth of here's what freedom means. And this is the freedom we're pursuing in the American experiment. And Alito says, hold on, that may be one view of liberty, but that's not the ordered liberty that we see in the Constitution. And so this is an important point, something we've been talking about for a while. And I was grateful while reading this to see that Justice Alito also commented on, look, these are two different views of the word liberty. A couple other final things from the opinion. The opinion did talk about the reliance issue, that if a law has been around or a decision's been around for 50 years, people can certainly come to rely on it. And he noted that this is different from, say, an investment in a particular type of industry or product, that a law would say, hey, you can do this particular action or raise something, or even business contracts, in the sense that human pregnancy is very time limited, and that a woman could decide to become pregnant, and that's a kind of a 9-month issue. Some of the state laws are even something like 15 to 20 weeks. And so this is even if somebody had, in a sense, relied upon it in the past, they could amend their behavior based on this law being passed. And so the reliance issue was not a bar to overturning Roe versus Casey. And then another key kind of last important part of this particular draft opinion was the fact that this issue, because there is no enumerated constitutional right to abortion, then under review by the Supreme Court, as long as the state has a rational basis for passing a law, then it will withstand federal constitutional scrutiny. And so Alito says here, it must be sustained if there is a rational basis, the law must be sustained, if there is a rational basis on which the legislature could have thought that it would serve legitimate state interests. And he goes on to list the legitimate state interests. These interests include respect for and preservation of prenatal life at all stages of development, the protection of maternal health and safety, the elimination of particularly gruesome or barbaric medical procedures, the preservation of the integrity of the medical profession, the mitigation of fetal pain, and the prevention of discrimination on the basis of race, sex, or disability. Sometimes abortions, the decision to abort are based on those, and there are state laws. We have one in Indiana that would prevent abortion based on those factors. And so that's the basic opinion. I'm sure many of you have read it. I did want to point out a few key parts of that opinion. And in case, and again, we're praying for that becomes the law of the land. Now, a good question is, well, what happens? All right, the issue gets thrown back to the states. And this actually fascinates me. So I guess give me a moment while we kind of nerd out on some of the legalities here. But I think it's interesting. What happens then? Well, there's a great website called afterroe.com. We'll link to it in the show notes. It has a list of all 50 states, so you can look up your state and where it is. But just a brief overview. If Dobbs is actually decided in the way that we think it might be, and it throws the issue back to the states, you have 13 states with what are called trigger laws that have been passed saying if Roe versus Wade is overturned, then we will ban abortion. They are currently enjoined in the sense that the federal courts have said, look, these laws are unconstitutional. See Roe versus Wade and Planned Parenthood versus Casey. If Dobbs goes the way that we hope it does, those injunctions would not just naturally fall off. There would actually have to be motions, in a sense, to remove the injunctions, but that could be done very quickly. So you'll see kind of a flurry of legal activity. I was talking to a pastor actually this morning, and he's it's probably going to be a good time to be an attorney in the space here, whether you're on the pro-life side or pro-choice side. There's going to be a lot of work being done in this space, and that is true. It also interests me that the states that had laws that were on the books when Roe came down, the argument is that they actually have been on the books the whole time. If they haven't, if the state legislature has not moved to remove that law from the books, then theoretically that law comes back into place. And Justice Alito, in his decision, has an appendix that lists many of those laws. So it is interesting to think that states that had not repealed any law that was on the books, that theoretically that law locks back into place. Of course, there might be litigation saying, look, it was passed in the 1800s and it hasn't been applied in 50 years, and so it needs to be updated. So those will be some interesting cases. Also, there are states that have actual constitutional provisions where the people of the state have actually gone to the polls and they've passed an amendment to their constitution saying that we respect the right to privacy, our reproductive freedom. They frame it differently in different states, but states like Massachusetts, Florida, Alaska, Illinois, Kansas, Iowa, Minnesota, and Montana have these in place. And I know that at least in Iowa and Kansas, maybe in other places, there are efforts to actually amend the state constitution to remove that provision so a law could be passed banning abortion. Another issue that could develop is this idea that, well, if you have a state that's passing abortion laws saying you can abort your child up until birth, in a sense, that depending on how strongly worded the Dobbs opinion is, the pro-life advocates may come into the states to say, hey, this is so far beyond the pale of what the federal constitution states that your law is unconstitutional. So there might be some challenges kind of trying to work out the intersection of state law and federal law on these issues. Of course, those on the pro-abortion side would say, look, this is a state law issue and our state constitution allows it. And so there'll be some interesting cases going back and forth on that. Now, there have been pro-life advocates that have already noted that, well, certainly there's no unenumerated right to abortion. But if you read the 14th Amendment, it says this: no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. There have been efforts previously to say that an unborn child is a person, and so that the right to life isn't an unenumerated would not be an unenumerated right, that it's actually enumerated. That when the 14th Amendment passed, that it meant that these individuals would have the protections of the law. So might be efforts in the future to say that not only was Roe versus Wade, Planned Parenthood versus Casey wrong, that there's no right to abortion, but that there actually is a right to life. And so I think you'll begin to see some of those efforts. A couple of the developments that might happen is you might have non-enforcement by prosecutors or by state agents in states where maybe a more conservative state passes a law banning abortion, and yet you have some law enforcement officials that say, we're not enforcing this law. And then, particularly because the abortion discussion and even some of the pregnancy care center movements have been shifting to address the fact that a lot of times when a woman now gets an abortion, they're not necessarily going to a clinic. Rather, they may have a telemedicine appointment, and then they may get some pills in the mail. And that's how a lot of this is done. So they're at the federal level, there are efforts to look at, well, can the federal government, through some of its programs, pay for travel for abortions? Now, I think that would be barred by the Hyde Amendment, but other ways to pay for pills. And so what happens if a woman that's in, say, my state, Indiana, travels over to Illinois? Illinois has already advertised for some of this, picks up abortion pills, and then brings them back to Indiana and takes them in Indiana. So will there be laws that have to address those particular scenarios? So again, this all fascinates me. It's going to be a flurry, a rush of legal activity if the Dobbs draft actually becomes the law of the land, becomes the opinion of the court. Of course, there was an effort just this week to pass a federal law, basically taking Roe versus Wade and just putting it into federal law. And if the makeup of the United States Senate, the House, the White House changes, you could see a law like that passed or attempt to be passed again in the near future. That's certainly foreseeable. Again, I would point to afterroe.com. That has a list of all 50 states and some great resources there. So if you'd like to look at that, you can see where your state is. So again, we talked about what are potential outcomes, what are some of the legal implications if the Dobbs draft becomes the final order of the court. And then I'll turn now to what's next for the church. So what's next for the church in the sense of what are we going to do? Depending on how the court, what are we doing? And I think the first thing is, how are we going to communicate well with our neighbors about this? Talking to a pastor yesterday, having conversations with people in his congregation about this, and some of them on differing sides of what's going on. So just a couple talking points is that I think it's important for Christians to remember that our belief in the sanctity of life is a pre-political biblical belief. We believe that every person from conception to natural death bears the image of God and is worthy of the protection of our law. Psalm 139, 13 through 16, Jeremiah 1:5, Luke 1:32. So how this works out in politics is very downstream from our belief. And certainly there are Christians that would claim to have differing views on this. But I come back to the authority of Scripture, the grand narrative of Scripture, and the fact that we bear God's image, and that even in our mother's womb, God knew us, and we bear his image, and we merit the protection of the laws of our land. And I think this is the great moral issue of our times. It certainly works out in politics, but that is the original issue. It is a pre-political biblical belief. It's also important to remind those around us, and I've even heard of some national figures that were surprised when they learned this, that our abortion laws in the United States are actually extreme. Now, you hear that word thrown around in the public square, but no, literally, out of all the nations of the earth, there are only 8 nations in the world that allow abortions after 20 weeks. And those include North Korea and China. So we don't want to be in a category with authoritarian regimes on this. So our abortion laws are extreme. And it used to be 7. Another nation changed the laws, I believe it was Colombia. 1 out of the 8 nations in the world that allow abortions after 20 weeks. To press into the idea of scientific advances since 1950, and you can look back at some of the ultrasound images, some of the technology around 1973 to what we have today. And everyone that wants to talk about science, Well, look at what medicine has taught us. Look at what science has shown us, that this is a little human being. And but for our actions would become a human just like us. It's just an issue of geography, right? They're in the womb rather than outside of the womb. And also important to remind our neighbors that we are seeking to protect kids and support mothers. And we're working to create a society where both can flourish. And you hear a lot of times, well, you guys aren't going to care for the kids. And, we don't have government programs to take care of all of these people. And we're going to leave vulnerable mothers without assistance and support. And that's simply not true. That many of the states that have passed some of these laws have been beefing up their programs to assist. And then the Christian church, the pro-life movement, has for now 50 years been putting boots on the ground, helping young women. And I would say, well, okay, if they say that, look, pregnant young women are not going to have the support that they need. Well, here, please call this number or contact me. We'll help with that. And so it's important for us to just stand by those truths and to point to the evidence that there's infrastructure here to assist young women that have a crisis pregnancy. So again, just a couple of things there. Things like, well, the laws here are extreme, scientific advances, and we're protecting the kids and the moms, working to create a society to support the both. And then inside the church, all right, so those are kind of things we'd say to our neighbors inside the church. And I thought the way that someone framed it this week was just perfect. And it was basically this, that our work is only beginning. Our work is only beginning. And I'm hearing that from anyone in the pro-life movement. And so I think that message is getting out there. One concern I do have is that if Roe versus Wade is overturned, I mean, that's what we've been talking about for 50 years. But that's certainly not going to be the end of the matter. Even if every state in the nation had a law saying that abortions are no longer allowed, the church's responsibility to go and care for and build community and support around young moms is still there. And so our work is only beginning. In fact, this is a remarkable opportunity for the church to not just proclaim, but live out the gospel in our communities. And so our work is only beginning. I think that's a great thought. Digging into that a little bit, what are some very practical things that we can do? And we've been talking to the head of the Department of Child Services in our state and talking to ministries about this. And there are a lot of great things that churches can do to dig into this. Things like baby boxes. We have them here in Indiana. Other states have them as well. And this allows a mother to drop off a child anonymously. No questions asked, no legal charges filed, no abuse or neglect charges filed. But if you come to a point where you just can't care for your own child, you can drop off that baby. These are in manned places like fire stations or hospitals, and that baby is immediately taken to the Department of Child Services, and you can move towards adoption or placement of that child. And there have been a number of kids that have been turned over in the state of Indiana within the last just couple of weeks and months. And so, again, that's another opportunity. If we're going to say, hey, we expect you to carry the baby to term, well, and if you're unable to care for the child, you can turn over that child, no questions asked. We, as a society, will find a loving home for that child. Of course, supporting your local pregnancy care centers. And I do think that the pregnancy care center, which was impacting every single zip code, just all across the country, that they're a key reason why we've gotten to this point, because the law is downstream from culture. And so the pregnancy care center, also things like building community around vulnerable families. We recently had an interview with an organization called Together for Good. There's another one in Indiana called Family Hope, where they're trying to identify vulnerable families, come alongside them, provide support to them so that the state doesn't have to get involved. Things like foster care and, of course, adoption. That our churches can dive in and impact these key issues and prove, not just talk to the world about what we believe, but prove to the world what we're doing. And I stand by the fact that the church is doing that well. There's always more to be done. But I am so blessed by all of the different organizations and churches I come across that care about this issue and want to make a difference. The last thing that I'll mention today, I always try to kind of boil everything down to a thought, is that the pro-life movement, many of the groups came together to come up with just kind of a single phrase or word, a single phrase to just state our position on this issue. And what they came up with is this thought: life is a human right. Life is a human right. And so the hope is that Christians all around the country those in the pro-life movement will share that simple truth that we are made in the image of God, and we merit the protection of our laws, the ability to be born without having our life cut short in the womb. So much going on in this particular space. I've heard many Christians say, I didn't think I would ever see this day. We've certainly been praying for it, thinking about it for a long time. And so we'll continue to track this. I'd love to hear some of your thoughts on how you think maybe the church could better serve those in our neighbors. But there's a brief review of where things might be headed and how the church can respond, how we can prepare for a post-Dobbs America.